Hello everybody, I'm Dr. Khushbu Mahajan, Research Fellow at Institute for Development and Communication, Chandigarh. Today we are going to record the module on ideological basis of Indian state. This topic is very important as it is regarding with the Constitution of India, because unless and until we don't read preamble to the Constitution of India, we don't come to know the philosophy of the Constitution, the ideology behind the Constitution. Thus, today's lecture includes the preamble to the Constitution of India, the fundamental rights and directive principles of state policy, that is the philosophy behind the Constitution of India. The objectives to today's lectures are to outline the basic values and ideals set out in the preamble to the Constitution of India. Secondly, to describe the philosophy of the Constitution and to understand the doctrine of basic structure, and to discuss the conflict between Parliament and judiciary with regards to the process of amendment. First of all, we need to know what is the basis of the preamble. The preamble was basically taken from the objective resolution, and it was based on the objective resolution moved by Pandit Jawaharlal Nehru in Constituent Assembly on 13th of December 1946, and the preamble page was designed by Biohar Ram Manohar Sinha of Jabalpur, who was at Shanti Niketan with Nandlal Bose at that time. The preamble to the Constitution reads as, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular and democratic republic, and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, faith, belief and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation in our Constituent Assembly on this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution." K.M. Munshi describes this preamble as political horoscope of the Constitution, whereas Thakurdas Bhargav says preamble is a most precious part of the Constitution and it is soul of the Constitution. In fact, it is a mirror through which we can peep into the Constitution. In nutshell, it describes the philosophy of the Constitution in all its words. The preamble of the Constitution has 5 features basically, and these features include sovereign, socialist, secular, democratic and republic. This preamble describes India as a sovereign state, secondly as a socialist state, thirdly as a secular state, fourthly as a democratic state, and finally as a republic. Now one by one we will take up these features and describe that what are the meanings of these terms individually and how do they matter in the whole Constitution. India is a sovereign state. In this term, it has been described that the locale of sovereignty lies in the popular will. It means that it is popular will that will decide the course of the actions and policies of the government. Thus, in the Constitution of India, primacy has been given to popular sovereignty with restraints over the constitutional sovereignty. In the second part of this term, sovereignty, India has been described as a sovereign nation. It means that India has right to make or unmake any decision without any internal or external interference, and this was also reiterated by Supreme Court in Keshwananda Bharti case. Further, in Beruberi and Union of India case, Supreme Court observed the weightage enjoyed by the Union government over the states governments on decision making. Secondly, India is a socialist state. What is the meaning of socialism? It has not been described anywhere in the constitution, and it is also the term which was not the part of initial preamble, but it was added by 42nd Amendment 1976 of the Constitution, and hereby the terms socialist and secular were added in the preamble to the Constitution. First time Janata Party tried to explain this term with 44th Amendment Act, but it could not be made possible because of the opposition from Council of States. Thus, socialism is an ideology which guided the Indian state after independence. Basically, there were some ideas like the adoption of 5-year plans, giving primacy to the directive principles of state policy, and public ownership of industries. These are some principles which projected the socialist credentials of Indian state and which describes Indian state as a socialist state. In 2008, Justice K.G. Balakrishnan reiterated that socialism is a part of basic structure of the constitution, and he rejected a PIL based plea in which he said that it can be deleted from the constitution as it is not the part of the original text of the preamble. Thus, this word socialism has been made the part of basic structure of the constitution, and it cannot be deleted from the constitution and preamble. India is a secular state. The word secular similarly was not the part of original text of the preamble, and it was again added by 42nd Amendment Act 1976. And secularism, what does the secular word means? Secularism means that the state has no official religion of its own, but it does not prohibit, or it did not prohibit, religion from public or private domain. Secularism is the founding ideology of the Constitution of India, and it has been declared as a basic structure of the Constitution, and it cannot be amended or it cannot be deleted from the preamble, and it cannot be amended. In S.R. Bomai case, Supreme Court of India declared the word secularism as part of basic feature and basic structure of the Constitution of India. There are many provisions through which secularism has been mentioned in the Constitution. There are Articles 27, 25, 28, Clause 1, Article 29, which assures the secularism of Indian state. Article 27 rules out public funding of the religion. Article 28 Clause 1, Article 27 rules out public funding of the state, whereas Article 28 1 Clause 1, which it prohibits the religious instructions in any educational institutions which are wholly funded by the state. Article 25, Article 27 and 28 are the guarantors of religious freedom in the Constitution, whereas Article 14, Article 15 and Article 29 Clause 2 imply a strict wall of separation between state and the religion, and Article 15, 16, 25 are also same in the interpretation by the Supreme Court in St. Xavier's Society case and Shah Bano case paved the way for a conflict between individual rights and group and community rights. Fourthly, India is a democratic state. By democratic state, the Constituent Assembly meant one person, one vote. It means that political freedom and political democracy. In case of democracy, there was a difference of opinion between Nehru and Ambedkar. Ambedkar said that this is a clear-cut contradiction to have political democracy without social and economic democracy, whereas Nehru had the different opinion. He said that this is the means to an end, that if unless and until we get political democracy, we can't achieve social and economic democracy. This term democracy was made was declared the part of basic structure by Supreme Court in Keshwananda Bharti case. Universal adult franchise without any discrimination on the basis of caste, color, religion, sex, creed. This was the basic which the Indian government wanted to achieve after independence, and it could have been possible only with the adoption of political democracy. Fifthly, in Preamble of the Constitution declares India a republic. What is republic basically? Republic is called the state where the people are supreme and public offices are open to the public, and the elected head of the government is not hereditary but is elected by the people. And the preamble of the Constitution reads India as democratic republic. It means that the head of the state is elected by the people and the representative, which means that head of the state is elected by the people and the government is run by the representatives elected by the people of India. While sovereign, socialist, secular, democratic republic serves as the foundational ideologies of the Constitution, on the other hand, the preamble also outlines the goals of these ideologies, which are justice, equality, liberty, fraternity, unity and integrity of the nation. Now we will discuss all these terms in detail. First of all, justice has been mentioned and it has been given priority over equality and liberty, as it is mentioned earlier before both of them. First of all, justice, socio-economic and political. The social and economic justice basically have been given priority over political justice. It means social justice means that the people are not discriminated or the citizens are not discriminated on any grounds based on sex, caste, color, creed, religion, and nobody will be discriminated on these grounds. And economic justice means that poor and the rich are treated equally in the state of India, whereas the political justice means that everybody will be given a share to take part in the processes of the government and in the governmental activities. Secondly, liberty. Liberty is not mere the absence of restraints, but it gives the notion of positive liberty, which means that everybody has the right to freedom. Article 19 is a reference in this regard, which gives the freedom of speech, expression and assembly, etc. Whereas Article 25 to 28 gives the religious freedom and ensures the freedom in case of religion. Then Article 29 and 30 protects the cultural and minority rights of the people, whereas Article 29 and Article 30 protect the cultural and educational rights of religious minority in the Constitution, and all these rights have been mentioned in the part 3rd of the Constitution, which deals with the fundamental rights of the citizens of India. Liberty is a sham without equality. Liberty and equality are basically complementary to each other, and both are incomplete without each other. The preamble ensures the equality of status, which means that everybody will be treated equally without any discrimination on the basis of color, caste, creed, sex, etc. Whereas the equality of opportunity describes as the equality before law, which means that everybody will be given equal chance, everybody will be given equal opportunity, and nobody will be discriminated in case of public employment. Here it is pertinent to mention that the Constitution of India gives the government the right to give protective discrimination, which means the affirmative action, that in order to make those people who have faced discrimination since ages, to make them at par with others, the government has the right and the constitution has the right to make positive discrimination and the provisions for the positive discrimination for such classes. For example, the Article 17 of the Constitution prohibits untouchability, and same as that there are so many other articles. For example, Article 15 and 16 uphold the provision for the rights for marginalized sections of the society like scheduled castes, scheduled tribes, and other backward classes. The idea of fraternity has been best explained in Article 51 Clause A in the part of fundamental duties. Here in the Constituent Assembly, Ambedkar had remarked on the idea of fraternity. He said fraternity means a sense of common brotherhood of all Indians, of Indians being one people. It is the principle which gives unity and solidarity to social life. Dignity of the individual. Then dignity of the individual is the idea for which the goals of justice, liberty, and equality are the various dimensions. They should finally guarantee the dignity of the individual, and there are many provisions which guarantee the dignity of the individual. For example, Article 17, which prohibits the untouchability. For example, Article 23, which abolishes the forced labor. And further, there are many provisions which prohibits any such discrimination found under the dignity of the individual. And it has been found that the dignity of the individual should be guaranteed by the Constitution under Article 21 Clause A. And most recently, the Supreme Court has observed and interpreted the right to life as right to life and integrity of the individual. The term unity and integrity, basically in which the term integrity has been added by 42nd Amendment 1976, and this has been added by the Constitution Amendment just to prohibit and just to prevent the tendencies of secessionism, regionalism, separatist tendencies among the people of India. Now the philosophy of the Constitution. We have discussed the terms and the goals behind and ideologies behind the Constitution of India, which has been remarked in the preamble and in the beginning of the Constitution, and we have a philosophy behind this. And in the last 50 or 60, 70 years, we have seen the working of the Constitution, and we have seen the importance of these terms, and by the passage of time we have looked at the philosophy of the Constitution. In Berubari Union case 1960, it was held by the Supreme Court that the preamble is not the part of the Constitution and thus it cannot be amended. But in 1973, in the Keshwananda Bharati case, it was reiterated by the Supreme Court that preamble is very much the part of Constitution and it can be amended by the Article 368 of the Constitution. Whereas in LIC case 1995, Supreme Court again reiterated its decision that it is an integral part of the Constitution and it cannot be changed. the question regarding the basic structure doctrine and the question regarding the amendment of the preamble first came in 1960 in the case of Beruberi and Union of India, and it was declared in that case by the Supreme Court that preamble is not the part of the constitution and thus it cannot be amended by Article 368. But in Keshwananda Bharati case in 1973, it was declared that it is a part of the constitution and it can be amended by Article 368 without changing the basic structure of the constitution. And the terms like sovereign, socialist, secular, democratic, republic, they have been described under the basic structure principle and basic philosophy of the constitution, which cannot be amended even if the preamble is amended. And the preamble has been amended just once since then, and this was amended in 42nd Amendment Act 1976. Until now, the preamble has been amended only once, and that amendment was done in 42nd Amendment Act 1976, and since then no other amendment has been made in the preamble to the Constitution. Concluding today's discussion on the ideological basis of Indian state, it is important to mention here that perhaps the entrenched constitution in forms of basic features and basic structures is important to protect the basic ideas and values outlined in the preamble to the constitution. On the other hand, it is also important to understand that what constitutes the basic structure and what constitutes the basic philosophy of the constitution, and who is the final interpreter of the constitution in case of parliamentary democracy, whether it is Supreme Court or whether it is Parliament itself. Thank you.